start the recording. All right, I'd like to welcome everybody to this month's risk management, risk reduction class, where I'm going to talk about the June 22 forms release. We're a little bit ahead of the curve. For years and years, I've always made an effort to stay ahead of the curve so that when the forms come out, you're already exposed to them. So I'm going to talk about forms. They're not available yet. The final version of them is not available, but I have access to them. And with a couple of exceptions, I'm going to show you forms that will, in all probability, be exactly what you will see in June when the new forms are released. There's not a lot of complicated things, a couple of new forms that are kind of nice. And I just want to take you through those forms and get you familiar with them. And again, the handout that I sent out, do not use those forms. Those are for your information only. A lot of them have red printing in them to highlight the changes, makes it a little easier for you to be aware of them. And I'm going to take you through many of them, not all of them. There's too many. This is a very large form release, but a lot of the revisions are relatively minor and not anything that we need to spend a lot of time on. Let's go through the forms that I do want to talk about. Let me share my screen. If I can, didn't jump ahead of myself here. Wait a second. Share screen. Share. Okay. Can everybody see my screen now? Yes. Good. All right. There we go. All right. As always, if you've got any questions, call. If you call the office, the best way to call, quite frankly, is the direct line. It rings right at my desk. You'll go straight to my voicemail if I'm away from the desk or on the phone. Most of you have realized I will call you back, and I'll call you back quickly. I don't have a habit of waiting until the end of the day to call all my calls. I call them back as in the order I get them as quickly as possible. So call the direct line. If you reach me, great. If you don't, leave a voicemail. Know that I will call you back. And of course, you can always email me at remaxconnectionsca.com. And on weekends and evenings, I'm available by cell, of course. And it's always best to text me and ask me to call you. But if you call my cell and I hear the ring, I'll pick it up. I don't often turn my ringer on, but the text messages light up, and then I'll call you back as quickly as I can. All right, with that, let's get into the new and revised forms. You've got a handout. Hopefully you've accessed that. Maybe you printed it, or at least you have it beside this screen so you can look at the forms as I talk about them. And I do have them on the slides here, so you'll see what we're talking about as we go through. This is the June 22 release. It's going to be released in late June. And like I said, most of the revisions are relatively minor, a couple of major things, and we'll talk about them. The first thing in your handout is the summary, and most of you have seen this over the years. It lists all the forms, and there's 6 pages, which if you follow this like I do twice a year, they do it in June and again in December, of course. This is a pretty large release, but a lot of this is things that were required because of changes in the law, and they simply added a phrase or two to the forms. And so as usual, they break them up into new forms and revised forms. They also discuss at the end of this summary forms that are being deleted. A lot of the COVID forms are going away. All right, so let's take a look at one of the things I want to break out. I'm not going to go through this in detail, but I'll give you sort of an overview. They revised, I believe, that you're going to see 7 purchase agreements, including the RPA. So the 7 purchase agreements, the ABSPA already built subdivision purchase agreement, not going to talk about that. Not a lot of people need to use that form. Common to all of these purchase agreement revisions is they added a clause about the Fair Appraisal Act. And there's a Fair Appraisal Act addendum. It's new, and you'll look at that in a moment. And so they've referenced that on all of these purchase agreements. Why? Because civil code requires it. Civil code requires that the buyer be advised that there is a Fair Appraisal Act. and there's a course of action they can follow if they think they were unjustly discriminated against. And I'm going to talk a little bit about that in detail. So all of these forms have that added. And so there's a condominium conversion, subdivision purchase agreement. You don't use that too often. The commercial property purchase agreement. Some of you might use that once in a while. And again, the revision was the Fair Appraisal Act reference. The NCPA, it's the only purchase agreement that does not have an appraisal contingency in it. So that one doesn't have any reference to the Fair Appraisal Act. Notice of default purchase agreement, we're not there yet. Be aware, some of you know this, some of you might not. It's real important. If a if a seller is occupying the home they're selling, and a notice of default has been filed against that seller, it is unlawful to use any other purchase agreement than the NODPA. Now, let me say that a little more correctly. The NODPA is not required by law, but all of the things in the NODPA are required by law. And so if you use any other purchase agreement for an owner-occupied 1 to 4 units, that the seller has a notice of default filed against them, you want to comply to all the regulations you're supposed to comply with, otherwise you can get in trouble. And the NODPA takes care of that. And that's not too common now. It was pretty common back in 08, 09. Might come up as the economy takes a little hit, and maybe some of these folks who have bought homes very, very expensive, and now they're having trouble paying for them, maybe, and now they're going in default. So just be aware of that. Not a big deal. RIPA, that is same thing. The Appraisal Act reference. The RPA, of course, has the revisions as well, and they also have they added a clause, a simple line that says if the seller is remaining in the property, the buyer should check with their lender. So that they added that phrase, and then the Fair Appraisal Act phrase as well. The vacant land purchase agreement also. All right. Now they also revised 4 listing contracts. So the first one, the CLA, the commercial residential listing contract. Now that can be used for any commercial rental property, regardless of how many units. They added to that, to the CLA, information about the advantages of MLS. So, those of you that, fill out listings from time to time, listing agreements, know that a good part of the listing agreement has a good bit of information about the MLS. That's been added to the CLA as well. And then the RLA, you're very familiar with that. They deleted from, by the way, all of these listing agreements, they deleted a clause that allowed the prevailing party in a lawsuit to recover attorney fees. That's is compatible with Carr's position. They did the same thing on rental agreements. The fear that Carr has is that contingency attorneys will go after brokerages, because brokerages are traditionally deep pockets, and make a nuisance of themselves and collect attorneys' fees as well. And if a party wins, they get their attorney fees. So by taking that out of the contracts, it sort of makes sure that doesn't make sure, but it tends to ensure that a party is going to have a legitimate claim before they sue a brokerage. Because if they lose, they're going to have lost all the money they spent on an attorney. Well, even if they win, they're going to, have to pay their own attorney. I guess that's the point. Whether you win or lose, you pay your own attorney. That's really the point. Okay. The RLAN, which is the open listing agreement. Hopefully none of you are using that. If you're thinking of using that, you might want to talk to myself or Larry. And that's not something we encourage at all at RE/MAX Connections. And then finally, the residential listing agreement seller reserved. And that is simply where a seller agrees to list, but maybe they were a FSBO and they want to reserve a buyer who told them, oh yeah, I'm going to come back, I'm going to write an offer. If you've been in real estate a while, you know that doesn't happen very often, but sometimes FSBOs think they have a hot buyer. And so, yeah, I'll list with you, but if this hot buyer comes back and buys it, I don't want to pay you a commission. So this is not a bad form, especially if you're using it with a FSBO or somebody, wants to reserve because their neighbor promised them he'd buy the house. And, I don't want to pay a commission if he buys it. Again, it doesn't come up too often that that's what will happen. Okay, so those are the forms. I'm not going to go through those in any more detail than what I just talked about. You can access them in June. The revisions, you can access them now, but you'll be getting the old forms now. Let's talk about new forms. So the first new form, and this is kind of nice, but I want to be sure you understand how it's used. This is the designated electronic delivery address amendment. And so this is designed to be used to either establish an electronic delivery address if one was omitted from page 16 of the RPA, or to modify one. And so the CAR came up with this new form so that if you didn't have an electronic delivery address or you wanted to change it, you had a formal way to do it. So the thing I want to point out, because that's the top of the form, is used to establish or change an electronic delivery address. And remember what delivery is how delivery can be accomplished now. If you simply send a document to the designated electronic delivery address, it is deemed delivered. And so it's a pretty good idea to have that address so you don't have to track down the other party and mess around if you're emailing it to them, but you don't have a designated electronic delivery address specifically stated in the agreement. You're going to have to sort of prove they got it. But if you have the designated electronic delivery address in your agreement, all you need to demonstrate is you sent it. It's as simple as that. So that's a good thing, like I said. Now, here's the clause where you can designate the either the new or for the first time, the designated electronic delivery. And so you'd write down that delivery address, the text number, maybe an alternative, and it's important you check on who this is for, the buyer's agent or the seller's agent. This is important. This cannot be or should not be dictated by the other party. So the buyer's agent can't tell you what your designated delivery address is. Likewise, you as the listing agent can't tell the buyer's agent what their designated delivery address is. So the fear when this form was first created was agents might misunderstand. They're just going to, I'm the listing agent, and they're just going to say, Walt at waltklein.com. That's the address. If we send it to that, Walt, you got it. Well, no, I don't agree. I don't use that in business. So note that to be completed by the authorized agent identified. So if this is the buyer's authorized agent's address, this must be filled in by the buyer. So a listing agent who gets an offer that doesn't have a designated delivery address, you want to return the blank form to them, maybe memorialize yours, but ask them to please complete this and get it back. And of course, if they don't, there's no law that says they have to do it. It's not even a national thing, so I'm not sure the code of ethics is ever going to come to play. You're just going to have to deal with it. If you have a trouble, give me a call. Maybe I can help you. Sometimes I can get things done by the other side that, you struggle a little bit. I'm not any better than you. I just have a title, and sometimes the title, gets their attention. So, but I want to be sure you understand it must be completed by the agent whose address is there. And then to memorialize that, the parties sign it. See, so if you did complete it and the other side did sign this, I would argue that was legitimate, but it could be problematic. All right. Now, if you have any questions at the end, I think we'll get through this quick enough. I'll answer any questions. You want to interrupt me? I guess that's all right too, but maybe till the end, we'll go through all this. Okay. The Fair Appraisal Act Addendum. Remember, that's what I referenced. The law now requires that be made a part of any purchase agreement, 1 to 4 residential units, which the buyer is going to be occupying, and it basically states that an appraisal cannot be biased relative to protected classes. My fear personally is I think this is going to get abused. A buyer is going to get an appraisal he doesn't like simply because the appraiser doesn't bring in a value, either right or wrong, and they're going to file a claim because the law allows them to file a claim. They're supposed to tell the mortgage broker, and the mortgage broker is supposed to respond, and the buyer, can also go directly to the government. And this is all mandated by law. A buyer must know this. The purpose of the law, and I guess they have documented that some appraisers will have actually reduced appraisals based on the ethnicity of the pictures in the house. As horrible as that sounds, I'm not telling you anything you don't know exists in our society, unfortunately. So that's the reason for the law. And if that happens, that's an actionable item. The government can go after the appraiser, and the buyer can get a new appraisal. Now here's the interesting thing you want to keep in mind. This is simply an issue between the buyer and the appraiser. It is not an issue between the buyer and the seller. So I want to kind of clue you in a little bit. Just be aware of it. I'm fearful that some buyers will utilize claiming this in order to somehow delay their performance on a contract and not remove appraisal contingencies, and try to somehow imply that the seller's got to work with them because, they were discriminated against on the appraisal. Well, a seller can choose to do that if the seller thinks that's legit. The seller is not involved in this. This is not a contractual requirement of the seller to recognize this. The seller can't sell or refuse to sell to a protected class, of course, but that's not what we're talking about. It's the appraisal. So I hope I'm sort of clear on that. Be cautious of that. And again, if you're in that situation, give me a call. But frankly, maybe I'm looking at it a little bit too skeptically, but I'm a little concerned that eventually buyers are going to figure out that maybe they can somehow, they get a low appraisal and somehow tie the seller up while they dispute it, and they dispute it for one of these reasons, rightly or wrongly. The seller's not obligated. This law does not impact the seller. There's no requirement for the seller to put a hold on selling their house because the appraiser violated the Fair Housing Act, where these protected classes are contained. Okay, now the non-standard forms advisory. Carr's been talking about this for months and months and months, and I did not develop our own in-house form because about 6 months ago, Carr said they're going to develop one, and so I thought, okay, I'll wait. This is an excellent form, by the way. We always get, we don't always, we frequently get non-standard forms, and some of them can be quite problematic. Now, you got to be careful. I'm in a glass house. I mean, if you go into Agent Hub, there's more than 36 non-standard forms that I've created, but I've sort of been careful in their creation. Not always the case. I've seen non-standard forms come in on transactions that are, illegal, and so or contain clauses they should not contain. And so this is a form to address that issue. And let me take you through the form a little bit. First of all, the transaction documents that identifies that there are, transaction documents are created by usually entities that know what they're doing, local associations of realtors, state association of realtors, and they're used to facilitate the transaction. And there are contractual considerations contained in these documents that, buyers and sellers should be aware of. So there's a sort of a general overstatement. Now, the next thing they talk about to some degree is the fact that there are advantages to standard forms. And the advantages are, and they list them there, one, are prepared by people who know what they're doing. They tend to be familiar with real estate. They often tend to be attorneys. Cars attorneys ultimately draft all the forms we use. Agents suggest what they like. We have meetings, and then the attorneys end up putting together the form. So they're designed by professionals. They're widely available, and that's important because one of the things that I've always advised our clients when they've gotten a non-standard form and it's kind of serious, I've put in writing to the client, we're not familiar with these forms. We're licensed and we're familiar with forms that we use every day. It'd be hard for you to successfully argue, gee, I wasn't familiar with the RPA. You have a hard time prevailing. But you can say, I'm not familiar with XYZ Realty's special disclosure addendum. Well, I don't deal with XYZ Realty very often. I'm not familiar with all the nuances of that special addendum anyway. So that's a legitimate statement. So they talk about that. These are widely available, which means they're familiar. And in theory, they do not favor one party over the other. They're not written with the attempt to take advantage of one party over the other party. I would argue some car forms, and sometimes, in fact, I'm going to tell you one in this class that tend to favor one party or the other. That's only because the language is very clear and one party benefits from that language. What am I talking about? Well, one form is the SIP, and I'll talk about that at the end here. Okay, and so they talk about the fact that non-standard forms, not so much. They may not be written by people that are knowledgeable or attorneys, or, I've written these forms. I'm not an attorney, but I've never written a form I didn't get blessed by an attorney. So, but they point out that some of these forms may not have the advantages that the standard forms have. And to that point, and they list very nicely the things that I've seen, and that is, sometimes these forms have waivers of rights you can't even waive. And so, be aware of that. They also have, blanket removals of all contingencies, and that can be problematic. They also sometimes create some sort of passive contingency or contingency removal that's just time sensitive, and that can be very problematic. And then finally, my favorite, form I don't like, kind of a double negative, is contract clauses requiring non-refundable or automatic release of deposits. So, they are in many cases actually illegal. Just like waiving your right to a TDS is illegal. Most agents know you can't waive a TDS. Many agents think you can have a non-refundable deposit. Well, if there's liquidated damages and it's 1 to 4 residential units with a buyer occupying one of the units, you probably can't, because the civil code, the liquidated damages civil code, is very detailed, and any clause that calls for a non-refundable deposit has to address that code. So we've talked about that in the past. So this form points that out very nicely. You got some kind of non-standard form, and then a very nice broker advice section that, these are not standard forms. We may not be familiar with them, and we're advising you to seek legal advice before you execute them. I've advised other agents too, and I've advised other TCs. Diane has, she's been doing it long enough. She knows what to say. Whenever we get a release, from the other side, Diane has a standard clause I wrote. It's pretty simple. And it basically says this form that you're asked to sign, because you have to provide the form. You can't say, well, non-standard, I'm not going to give it to the client. You can't do that. But you can tell the client, with this document especially, this is non-standard. And you want to talk to an attorney before you sign it. Usually when you tell your client that, they don't sign it. Diane says this document from the other side contains a release that may impact your legal rights. Before signing this, you should consult an attorney. Diane says the common response is a phone call or an email. Do I have to sign it? No, I don't want to sign it. And, that's good, because we don't want our clients making pre-releases, and compromising their rights. They have to do a release later if there's a dispute, but no pre-releases are correct. Okay. So That takes care of the new forms or the important new forms that you're going to be seeing more often than not. Now let's talk about some of the revised forms. So the first form they revised a little bit was the cancellation of contract and release of deposit. So let's look at that in a little detail. And of course, you're familiar with the form. Unfortunately, you've probably seen it a few times. And they didn't revise any of this, but I want to take this opportunity to remind everybody of something that's very important. And the first is, frequently one party is canceling. And so they send over a cancellation, and often the other party doesn't agree. And so the party that's canceling, let's say it's the seller, somehow thinks they'll soften the blow if they check the box both. I'm here to tell you, only check the box both if both parties say, you know what, let's just cancel. I don't want the house. You don't want to sell it to me. Let's cancel. Well, then it's perfectly appropriate. But if the seller is initiating the cancellation and the buyer doesn't necessarily want to, doesn't mean he doesn't have to, if he's violated the contract, he's in default, he might have to. But if he doesn't really want to, at least let the documents, the record reflect it was the seller who canceled and not both, and likewise, if the buyer is canceling, but the seller doesn't really want him to, but maybe the buyer has the right to cancel, well, then the box would still say buyer is canceling the agreement, not both. Now, the next thing I want to point out is the rule of thumb, and I love the way this is worded. They changed the wording on this many years ago to this format, which is the right format. They are canceling as permitted by the good faith exercise of a paragraph, not some specific reason. So sometimes nobody on this call, because you're all pretty well, you pay attention and you've all learned, don't put down, buyer doesn't like neighborhood noise. That, it might be that that's fine. He's going to be able to prevail anyway, but that's not really smart. Attorneys will tell you not to. Carr will tell you not to. Carr will tell you, as Walt will tell you, cite the paragraph that allows you to cancel. Don't cite the specific reason that you are canceling. That there is no requirement to do that in the civil code. And, best practices is give us the paragraph number as allowed by paragraph 12. We're canceling. Why? Because the buyer is taking advantage of paragraph 12. That's why. So that's the kind of important. Because B and C, you're pretty familiar with that. Either the buyer failed to do something, they were given a notice, or the seller failed to do something, they were given a notice, or either party didn't failed to close, they were given notice. Those are pretty standard. Mutual agreement, if they both want to cancel and they both are parting, hopefully as friends, then you can certainly check that. But don't check that if it's not a mutual agreement. And then, of course, the canceling party is the party that signs. You don't need the other party to sign the cancellation. Cancellation, I don't want to get in the weeds too much, but cancellation is a unilateral act of the purchase contract. Cancellation of an escrow is a bilateral act. So either party can sign this. Now, they may not prevail because they might still be obligated to perform. They just, that's a different issue. That's getting into the law a little bit. So, but it's a unilateral act. Now, the part two is the release of deposit and cancellation of escrow. By the way, that's bilateral. And so they talk about what part two does is, number one, it instructs escrow to cancel. And number two, tell escrow what to do with the deposit. Then they have a clause that says that the deposit release is not automatic. So the other party should be aware. Look, just because you cancel doesn't mean you get your deposit back. If you canceled for cause, you don't get to keep the deposit. So, and that clause addresses that. All right. The next thing is where there are a couple of changes. They made it a little clearer that if the property is a 1 to 4 dwelling units and the buyer intends to occupy one of them, then the liquidated damages are limited to 3%. So they clarified that a little more to make it real simple. And then they also added something which comes up all the time. So this is kind of nice. What if there's no deposit in escrow? What do we do with the deposit? Well, in the past we've said, well, just write NA somewhere. But now you actually check a box. There is no deposit in escrow. So that works pretty good. And then, of course, partial release of deposit and reservation of rights. That's always nice if you're the seller and they're fighting over the deposit. It's nice to have the buyer memorialize, we're gone. And so that allows you to sell the home without a backup addendum. But if you don't have the buyer canceling, you've got to sell the home with a backup addendum. I mean, no law says you have to do it, but Walt's going to tell you that. Mike's going to tell you that. Larry's going to tell you that. Jeff's going to tell you that. Why? Because you might have sold it twice. And as the agent, you should have known better, and you don't want to do that. So if you cannot get the buyer and the seller to agree on a deposit, see if the buyer will agree to either a partial reservation or that they will, hold the deposit until they get an award or decision later. That would, that is a cancellation of the contract in the escrow. But just simply dealing with the deposit later. So that's pretty straightforward. All right, COP, not a big deal with the COP as far as changes. They did put in that the seller may use the bottom of page 2, and we'll look at that in a moment, to give notice under the COP. So if you're familiar with the COP, you know that in paragraph 7, you have, first of all, you have a right to market the property. You have that right always. You have a right to accept backup offers. You have a right to that always. Again, backup offers. Don't accept an offer any other way than as a backup offer if you have another offer in front of it, if it has not been fully canceled. So you have that right. So sometimes you can accept a backup offer and give the buyer a notice to remove their contingencies and go away. And so giving the buyer that notice can now be accomplished on the form. And so they made that clear on the form. Now, you'd have to have the right to give them notice. So immediate right is the boilerplate. But if they check box 3 and you accepted it without advising the seller, shame on you, because it says the seller, although he's resold the home to a backup, which he can always do, he can't give the front buyer notice to remove the contingencies because he has no right to notify the buyer. The buyer gets to stay in this transaction until some other clause in the transaction has been violated. Might be close of escrow. Could be that. All right. And then the notice, this is the notice that you can fill out and return it back to the buyer's agent, giving them notice that you've accepted another offer, and they need to remove their contingencies. And of course, with that removal, provide verification they can buy the property without selling their property. All right. That's usually involving a loan, or they have enough cash in the bank. They don't need to cash out on the other house that they're selling. Okay. Request for repairs. There's been a slight modification of request for repairs, and it occurs on the seller's response section. So they clarified a little bit on whether you're agreeing to all the buyer's requests or only some of them. And so if you're only going to do some of them, then you agree to the buyer's request except, and then list the things that you're not going to agree to. And then it talks about the fact that the seller is not obligated to perform unless contingencies are removed and you provide an attached CR. That's really important. I can tell you it's more common than you realize. Buyer cancels, they still have their contingencies, they get their deposit back, and the seller says, who's going to pay for these repairs? I would have never made these repairs, except for this buyer. So, to protect the buyer, at least have the contingencies removed. Protect the seller. To protect the seller, have the contingencies removed so that then the seller has access to the deposit. Doesn't mean he gets it, but he clearly won't prevail if there's still a contingency. Courts will not give a seller the buyer's deposit if the buyer still has any contingencies that are being exercised, so be careful of that. Don't, advise your seller, don't make these repairs yet until I get the CR back. It's as simple as that. And then it includes an expiration of the seller's agreement. If the buyer doesn't accept the seller's agreement within 3 days, then the seller can revoke his agreement to do the repairs. Okay. Now the seller's response there, I'm going to show you what's not there. I guess I'm going to tell you what's not there. I can't show you what's not there. So in the old one, the seller's conditions on doing the repairs was that the buyer releases the seller and the agents. well, that can't really be done, and it's contrary to civil code and case law. So Carr figured that out. It's been that way for a long time, by the way. I call this sort of a moral release. This release is, by the way, a moral release. I mean, you don't need to get in the weeds. You're not an attorney, but I'm going to tell you, this release would not protect a seller if the buyer decided to go after the seller. These releases, many of you have already heard this from me. For a release to be effective, there's about 4 pages of legalese. And I've already prepared a handful of releases since Mike's bought the company. The good news is I've been doing this for a long time, and I've had good advice from attorneys in the past, and it's pretty standard. But the only thing on the release that changes is a sentence or two about the specific situation. But what's critical is all these legal clauses that courts have said in the past, this release that I'm looking at is no good because it doesn't have some clause. So over the years, real estate attorneys especially have figured out how to write real estate releases that courts won't overturn. So I've been preparing these releases for 20 years. Knock on wood, not one has even been challenged. I've had a couple of attorneys suggest they were going to challenge it, but when they got the release, they went away. These releases are good. Don't want to get in the weeds here. I just want you to be aware. You don't have to give your seller legal advice. Carr is, putting this on the form. In many ways, I feel, you're misleading the seller if the seller thinks, I'm done. I have no concern. This buyer can't come after me because he agreed to release me. Well, maybe yes, maybe no. It's at least morally he has. All right. For sure, they had to take broker out of there. That their Carr recognized that and they took him out. So that's what's missing. That's the revision. Okay, the probate agreement purchase addendum. There's a couple of things they tuned up a little bit, and that's good. I'll show you that in detail. First of all, they said that the seller is not obligated to sign escrow instructions until they get court confirmation. It's as simple as that. The seller can, if the seller needs court confirmation, they're not obligated to do anything in an escrow until they get that court confirmation. And so the language of the contract doesn't necessarily make that clear. So the addendum does. If you're a listing agent and you're selling a property that's going through probate, of course, you're going to use this probate addendum, but and this is one of the protections the seller is going to get. The other thing is vesting. Courts will not allow assignments in probates. And so this is basically what it's saying. It's saying that we got to know who's buying this house now before we go to court. And so you got to tell us the vesting, who's the buyer, and some assignee. By the way, you shouldn't have assignee as a buyer because case law has ruled that buyers must be identified. Sellers must be identified. Someone's going to buy the house, but you don't get to know who it is yet, but you have to agree to sell it to them. That's not a legal contract. So these, and a lot of you know this, a few of you are learning it, and no harm, no foul, but you should not accept a purchase agreement that has or assignee on it. The contract, has addressed that a little bit. You should be aware of it. Call me if you have any questions. It clearly says that here. You got to tell us who the buyer is, who's the vesting, because I got to take that to court. The listing agent or the probate attorney, not the listing agent, but the probate attorney. And then it also removes liquidated damages, mediation, and arbitration from the contract because the court will apply their own damages, and the court's not going to agree to mediation or arbitration. They're the court. We don't need mediation or arbitration. I'm in charge. That's what a judge his attitude would be in a probate. So that's been removed from the contract. And then finally, this is very nice. I'm not aware of this, but I'm pretty sure this probably happened based on the fact this has been included. So the first buyer's offer is accepted subject to court confirmation, and then the overbid, another buyer got accepted. And the first broker wants his commission. Well, you accepted my offer, not my fault it got overbid. Well, I don't know if you're going to prevail. Well, now they've made it clear you're not going to prevail because it says right here, commission's not owed to the first broker if an overbid is accepted from another broker. So that's good. And then it also talks about the fact that the probate court has to approve the commission amount in overbid situation. All right, statewide buyer and seller advisory. Not any real super duper major changes, with one exception, and that's paragraph E. Let's take a look at paragraph E. So the first thing, I'll just tell you quickly what this says. It says don't zoom through these contracts. All of you know this, DocuSign, you just go next, and click away. And, my fear is always the client doesn't read it. So the good news is we have now in a document that's part of our transaction, so that if later the client says, well, I didn't read this, I just clicked away, because agents have raised that issue. Are we liable because DocuSign sort of directs them to the next paragraph and just clicks away? Well, Carr heard you, because they added this to the SBSA that you should not be doing that. It also talks about a limit on liquidated damages, and it also talks about release of deposits, a mutual decision, or a judicial or arbitration award. It defines liquidated damages, gives you a little more detail about liquidated damage. It also talks about if there's an additional deposit, that the form DID needs to be included for that additional, at the time the additional deposit is made, not included in the original agreement, but at the time the additional deposit is made, the DID is then executed, and that initial deposit can then be added to liquidated damages. Now they go on to discuss mediation a little bit, and they go on to discuss arbitration a little bit. I have in Agent Hub, I've taken the Carr booklet on arbitration and made it pretty. Did not remove the copyright. Carr is still on it. The copyright is still there, so it's perfectly legal. But I told agents that if a client ever asks you, should I initial arbitration or not, what's the best thing to do? You really shouldn't be giving them advice. That's a legal consideration, because there are some pluses and minuses to arbitration. And so that booklet points it out really nicely. I'll tell you the biggest plus to arbitration. And by the way, I would argue this form's a little misleading, I think. It's not necessarily fast or cheap. It could be, but not necessarily. But it is for sure confidential. Lawsuits are not confidential. Arbitration actions are not public record. So you'll find arbitration real popular in places like Hollywood or government officials. They don't want to be involved in any lawsuit that gets into the public record, because that, then the public knows about it. So that's a big plus. I recognize that. I'll tell you what a big minus is. If you're the loser, arbitration awards are not appealable. And this does a good job of saying that, even if the arbitrator made a mistake. Now, what is appealable is that the arbitrator was crooked. The arbitrator has to disclose that he has a relationship with one of the parties and excuse themselves. But if the arbitrator, somehow the brother of one of the litigants became the arbitrator and he made an award, that could be overturned. But the arbitrator could be completely wrong about the law. Too bad. Arbitration, it's binding. It is final. And that's been the court several times. And courts will not overturn a binding arbitration based upon the incorrect application of the law. That's how decisions are normally overturned. You lose in court, and then the losing party goes to court and says the judge misread the law. He didn't understand it, and the court looks at it and says, yeah, that law is a little more complicated than that judge realized. And they, overturn it on appeal. And of course, if they, whether they overturn it or sustain it on appeal, it becomes then case law, because lower courts have to honor higher court decisions. So if you sue somebody and you win, and then somebody else sues somebody else under the same issue, the second judge can look at the first lawsuit if he wants or she wants, but they're not bound by it. But if you sue somebody and you win or lose and it's appealed, and then the appellate court either sustains it or reverses it, the lower court must follow what the appellate court said. So that does not occur in arbitration. So that's the negative. The booklet points that out kind of nicely. It's nice to see it in this SBSA. Okay, seller's license to remain addendum. This is a nice addition. I want to address this real briefly. They added here that this SIP, if it exceeds 29 days, the buyer should advise an attorney because they may not benefit from the protections that the SIP may give them. And what protection am I talking about? I'm talking about the protection that you are not a tenant landlord, you're not in a tenant landlord relationship. The SIP, there's no law that says an SIP has to be 29 days. So I'm not familiar recently with two transactions where we've had longer than 29-day SIPs. And the two issues that you need to be aware of if you have a longer than 29-day SIP. One is, it's legal, and you can't say, oh, sorry, illegal, this has got to go away. No, it doesn't. If you're the one that has a 40-day SIP, just know the other side's going to push back frequently. We've had two offices, do everything, in their power, tried to tell us it was illegal. It's not illegal. But if you have one that's longer than 21 days, the other side's going to push back in all probability. The other thing you need to do is tell your client, the reason it's 29 days, and this form does that very, very gently. The reason it's 29 days or less is CAR believes they can win. You can win if you have an SIP for 20 days and then the seller wants to be treated like a tenant. See, that's the problem. Buyers don't understand landlord law. And if you have a tenant, this is no longer a seller in the house you bought. This is a tenant. And they have legal rights. You might not understand them, Mr. Buyer. And so CAR, recognizing that there's lots of problems with buyers letting sellers stay in the property, then the seller rather, trying to exercise some special right they have as a tenant. And then the buyer sort of screwed over because he didn't mean to have a tenant and a landlord. So CAR came up with the SIP, not civil code, CAR. And they kept it to 29 days or less, and I think they're completely right. They are convinced that a court for a 30-day or longer seller in possession agreement, the courts are going to say this is a rental agreement. I don't care what you call it. You call it SIP, you can call it an XYZ. We don't care. The seller is a tenant. So they feel they have a better chance, or you would have a better chance if you're involved, your client would have a better chance if you were involved in some sort of landlord-tenant dispute, but you use an SIP and they were only in the property for 10 days. Courts may well say, yeah, no, this is not a rental agreement. This is accommodating a seller who wanted to take 10 days to move out. And they have good reason to believe that. You should know this has not, to my knowledge, been taken to court. And I'm positive I would know. I get on a conference call with CAR Legal, the very top of CAR Legal, twice a month. I can promise you, if this ever goes to a litigation and to appeal, we're going to hear about it, and then you'll know about it. But right now, we believe, CAR believes, and I think they might be right, that as long as it's 29 days or less, you can probably get away with not being considered a landlord or a tenant. If it's longer than 29 days, 30 days or more, you probably won't. So they added this. That's the clause they added here, so that you could your client could be aware of that. And then finally, they do state that the buyer cannot put personal property in the form all in the property that until they take possession without written permission from the seller. The rest of this has always been there. It's good to point this out, and you should point it out to your buyers especially. And that is, just because you own the home doesn't mean you have unlimited right to enter the home. The right of entry on an SIP is dealt with pretty much the same way a rental right of entry of a landlord into a rental. The seller has, the right to quiet enjoyment, of the premises, of the residence, whether they own it or not. And so a buyer just can't show up, hey, I'm the owner, I get to come in now. No, there's specific reasons why you might come in, or I can agree to let you in. Hopefully that would be the case, but you don't get to just show up and walk in. Now, I did mention this, I'll share this with you. I think an SIP is a little more buyer-friendly than seller-friendly for one big reason, and that is the SIP requires the seller to maintain the property even after close of escrow. So, And you're going to say, well, how often does this happen? It's happened twice. And in both times, we had no home warranty. The home warranty wouldn't cover it. We've had seller occupied property owned by the buyer now because escrow's closed and the hot water heater went out before the buyer took possession. Prior to the SIP, by the way, both of those episodes happened prior to an SIP. The buyer was stuck having to replace the hot water heater. Seller lived there for a month and a half. The hot water heater went out. The buyer wanted the seller to replace the hot water heater because it broke while you were in the house. They went to court and the judge said, you have a tenant. Tenants don't replace hot water heaters. In fact, one judge said, this tenant wouldn't even have to replace a dripping faucet. They were sort of offended that the buyer even thought that the seller should replace the hot water heater. That's happened twice. So the nice thing about an SIP is with an SIP, if the hot water heater goes out or a faucet starts dripping while a seller's in there, possession to the buyer, when the buyer gets it, it must be in the condition it was, subject to any repairs made at the time the offer was accepted. So that's a buyer-friendly clause in the SIP. Now, what about walkthroughs? You don't have to do a walkthrough if there's an SIP prior to close of escrow. I recommend you do, because if the hot water heater's out, let's address it now. But if you do a walkthrough during, just before it closes, you should definitely still do a walkthrough prior to the buyer taking possession. So the night before, you do a second walkthrough. CAR is aware of the fact that that's not well addressed. So you got to sort of think about it and get good advice from people like me, perhaps, and then follow that format. And you're allowed to do that. You have every right to do that walkthrough. But they are going to amend the SIP to make it a little clearer that there is a walkthrough that could be done prior to close of escrow, but definitely for the buyer's protection should be done prior to possession. All right. Seller multiple counteroffer. The big change there is the fact that the seller can now accept a backup offer as part of the multiple counteroffers. So one of these offers, you're not going to take this particular offer, but you would accept this particular offer as a backup offer. And so that's been added to the contract and makes it paperwork a little simpler there. And then finally, the SPQ has a few changes. The one thing is, and I would, I'm going to talk about this perhaps next month, the use of a BMI. It's important in advice to the seller or notes to the seller and the notes to the buyer. They talk a little bit about what each principal should think about when they review the SPQ. And one of the things they point out is, the seller may not disclose something that's important to you, but the seller doesn't think that's important. Now, that doesn't mean the seller wouldn't be in trouble if it is ultimately important. So a material fact is a material fact, whether the seller believes it or not, and the seller should disclose it. But what they're saying is sometimes the seller won't say something only because they don't realize that that's real important to you. And so if anything's important to you, you should tell your concerns in a BMI. Now, a BMI is a document not between the principals, it's between the buyer and the buyer's agent. I have required Scripps Ranch, Escondido, and Fallbrook for, this is going back 10, 12 years. And I'm going to suggest that once I get all these things well established in Agent Hub, they're in there. And then we'll have a class on that. I want to introduce to the Carlsbad and Rancho Bernardo agents the importance of including a BMI in your buyer documents. What is a BMI? It's a buyer's materials issue document. And that's where the buyer tells their agent, me buying this house it's very critical to me to know about XYZ. And they list things. And sometimes they'll list quite a few things. But here's the good news. If that's critical to them, you should know that and you should advise them on how to address those issues. What happens a lot of times is they put none. And I don't want to do that whole class now. It'll run too long. But if they put none down and then later say, hey, I would have never bought this house if I knew that I can't have horses on this property. And here's the killer. And I told my agent. Well, no, you didn't. But on a he said, she said dispute, I don't have to tell you, the principals often get the benefit of the doubt. No law says that, but it tends to be the way things work out. I can tell you, and I don't want to bore you, but some of you have heard these stories. I can give you multiple lawsuits that we cut out in the inception when it was first proposed they were going to sue us because our attorney delivered a BMI. If this buyer was so concerned about smoking and would have never bought a house if they were adjacent to any smokers, and you told your agent that, and your agent should have helped you determine whether the neighbors or the other condo members were smoking, if that was so critical to you and you would die if you're exposed to smoke, why in the BMI did you write any issues or concerns? Yeah, I'm concerned about the carpet. It's kind of old. Wished I'd asked for a credit. That's it. Nothing about smoking in the BMI. Same with the horse property. I would have never bought this hot property if I didn't know I couldn't have horses. And I told my agent that. The agent said, I never heard of that. I didn't know that. And I believe the agent, quite frankly. The BMI, none. By the way, you don't write none, the agent does. I'm giving you a little preview of the class, but it's nice. The reason I point this out is the BMI is a good form. Those of you who aren't familiar with it, start looking at it. You're going to have a few questions about it, I promise you. Next month, I've already talked to Lindsay. We're going to put the BMI in the class next month. I want to get all of RE/MAX connections to start utilizing the BMI. Okay, this is important. The yes answer is appropriate no matter how long ago whatever you're being asked about is. Sometimes I get questions all the time. Well, they fixed it 2 years ago. Do I need to? Yes. Well, the neighbor was fighting with them about 5 years ago, but I think they've kissed and made up. At least the neighbor hasn't made any more trouble. Should I disclose it? Yes. By the way, anytime you ask, should I? Almost always the answer is yes. What I answer is, why wouldn't you? Well, I don't want to screw up the deal. Well, if this has a potential of screwing up the deal, the law says you have to disclose it. That's the definition of a material fact. So it's nice that the sellers are being advised of this. That's also in the DIA, the information addendum that we give our sellers before they disclosure information advisory that we give our sellers prior to them filling out disclosures. Hopefully you're all using that. You're supposed to. I think we're checking for it. Okay. It talks about if there's a death on the property, the civil code doesn't require you to tell how they died. And in fact, if they died because of HIV, you can't tell them. You can't. You're breaking the law if you say somebody died of AIDS. But the law doesn't say you have to, say whether it was a suicide, whether, the husband shot the wife or the wife shot the husband or whatever. You don't have to say that. But Carr has pointed out that sometimes lawsuits are filed because the manner of death the buyer felt was significant, was material. And so to avoid that, they simply want to tell the seller, the manner of death may be a material fact to the buyer. Be aware of that. And it may be disclosed. If you want to say, my father died of old age, that's probably a good thing. If you want to say my father was killed by 3 gunmen, that could be problematic. By the way, if it was a gang-related or hostile event, that is probably absolutely material, because the fear would be they might come back and not realize that the new occupant, a buyer, isn't a member of the old occupant's gang, and you don't want to come in and shoot the house up. So, when you have questions about that, give me a call. I can kind of walk you through it. But they're sort of telling a seller, you might want to consider telling us how the party died. But it's not in the law. It's not in the law. And then finally, they've added, I've got ahead. They've added a fact that I don't think anybody in the properties we sell, but maybe we do, if there is a flood insurance settlement from the government, it's going to require you, as a part of that settlement, civil code is going to require you to maintain flood insurance. And that's part of the settlement. And so now the new buyer, he has the same obligation, but the new buyer may not know that. So they put that in there. So if there was a flood and you got a settlement, the buyer needs to be advised that they have to continue paying for flood insurance. The condominium, quite a bit added to that, just more detail. And then finally, 2 more things. The features of property shared in common and encroachments, they added those specific questions. And then finally, this isn't in red, but this is new. B, if any alterations, modifications, or improvements were done as a result of cannabis cultivation, you need to disclose that. And we can laugh, but I'll tell you, I've had a couple of instances. One was a rental. Cannabis needs high humidity. And so what happens in somebody who grows, I don't want to, I'm not an expert on this. I want to make that real clear. But, one of the things you do is you line a closet with foil. And one of the reasons you line the closet with foil is, it helps the grow light work better. But the bad news is you also have a very moist environment, and the mold gets behind the foil, gets behind the drywall, and gets, prolific. If this person's been cultivating cannabis for a while. We had a rental one time where the tenants lived there for years, always paid their rent on time, never once called the landlord. When they finally moved out, the landlord found out why. That whole house was cannabis, and that whole house was so saturated with mold, it was horrific. They had to take all the drywall down to studs. So that's why this is here. It's there because, they're not going to get into the science. I know about the science because I have a science degree. I don't know anything about growing cannabis, but the science is cannabis is a tropical plant and it requires high humidity. And if you have high humidity in an enclosed environment, mold's going to grow. So that's why that's there. All right. Tenant occupied addendum. I think this is the last form. I hope it is. I want to get through this quickly. So for the purposes of the tenant occupied property addendum, a tenant is any adult living in the property who's not the owner of the property, not the seller. Now, it also has a clause in here that if the seller is going to remain, have possession after close of escrow, but there are tenants in there now, the tenants need to be removed. And you can specify when or make an exception. Okay, and then an RCJC is attached to the tenant occupied purchase addendum. Why? Because the buyer needs to be informed of the things that are in an RCJC. It is not part of the purchase agreement and need not be filled out. So it prints automatically. The box is checked, card, automatically checks that zip form does, and that prints, and it just explains why your client is getting it. Folks, that concludes my talk. I don't have my clock on. I'm hoping I didn't run too long. If there are any questions, Lindsay, are you looking at the chat? Probably. I'm happy to answer any questions. Otherwise, we'll call it a day.
There's a couple.
Great
So
job.
Vicki Varnals said that she's had to. She says I've had to counter this on most offers when representing sellers, and many agents leave blank. I think she was referring to the DEDA.
Yeah. Yeah, that's not a bad idea. You can put in the counter that and again, the counter is not coming from you technically, Vicki, but you can tell your seller, look, you want me to get this designated electronic delivery address so I can serve notices easily. So, let's put that in the counter. So that's a good idea. Yeah, you could counter that in, but again, you don't get to dictate it. That's the thing the one thing about that form, I think they should have put that in bold, that the party who's being identified is the one that has to say it. Now you can, no harm, no foul. So you have a good relationship with the other side and you say, look, what's your email? I'm going to put it in a form, I'll send it over. Can you sign it? Yeah, sure. No problem. Well, it doesn't matter, but don't think that you can dictate an electronic delivery address. Now, to Vicki's question, can the seller require the buyer to ask their agent to provide it? That's where you'd have to write it, buyer to instruct buyer's agent, because you can't require the buyer. I'm glad that Vicki answered that question. I'm glad I took a little more time to answer it. You can't tell the buyer's agent what to do in an RPA because it's not an agreement between the buyer's agent and anybody else. It's an agreement between the buyer and the seller. But the seller can say, if I'm going to sell this house to this buyer, I want to know what the buyer's agent's electronic delivery address is. So be sure you word it that way. If I confused anybody, give me a call. I'll give you exactly the wording. Maybe I'll put it together and have Lindsay send it out through Agent Hub, because that's a great question, but you got to word it correctly.
Dave Zeman says, can a seller cancel if the buyer won't sign one of their non-standard forms?
Probably not, unless you made that part of the agreement. For example, here's a perfect example. They probably can if you make it part of the agreement. We require, And again, I need to get the connections. I mean, the Carlsbad and the RB agents are a little more tuned up on this. The good news is our E&O is much more liberal, so I'm not losing sleep over it. But E&O has a big problem when agents sell their own property. There have been policies in the past where they didn't allow it. And then they would allow it if we did certain things. And as it turns out, those certain things are excellent to protect agents who are also the owner of the property. Because if ever the presumption of doubt, or the lack of believing you that they're going to doubt you works against you, it's when you're selling your own house. They're going to think you didn't act as an agent, you act as a seller, and you were very self-serving as an agent. That can be very problematic. Okay, so how do you, life, you get to sell houses just because you're an agent, how's that work? Well, there are ways to conclusively protect yourself. And so we have a set of guidelines that we want all agents who are principals of a transaction, regardless of how much they own, partners, whatever, or they're related to the principal. I don't own the house, my brother does. Yeah, but you're still close to your brother and you might be taking advantage of the other side, cutting corners, and that's what the other side will claim. So we have a set of things we want you to do. One of them is require that the buyer have the home inspected by a certified inspector. You can do that. A seller can do that. So you tell the seller, I'd like you to ask this. There's another form we have, which is an addendum to the purchase agreement. And it lists, I think, 9 or 10 possible inspections a buyer can have. And under each description of the inspection, they initial, not whether they're going to get it or not, but they're aware that they can have that inspection. Why? Because if they later sue us, we can say, look, they knew they could have had a mold inspection. They didn't get one. And we can prove they knew it, not because we told them we're their agent, but they signed this purchase agreement addendum. So that's in Agent Hub. If you spring that on the other side, I can promise you the other side won't sign it. But if the buyer is told in the counteroffer, in other words, you put in the counteroffer, buyer shall, and buyer's agent shall execute the addendum to purchase agreement. Now the seller is saying that's a condition of the sale. And of course, the seller likes it too, because not only will they sue the agent, they'll sue the seller, and the seller will have the benefit of, he was told about a mold inspection. He was told that he should check on permits. He was told that there's geological inspections you can get. He was told there was a roof inspection. She was told you can get an electrical inspection. And so that's an in-house form. Absent us putting it in the agreement, in the counteroffer, we've had many offices refuse to sign it. So I always tell agents, put that in the counter, because now it does become, an obligation. Hope that answered the question, gave you a lot of detail there.
Drew wants to know, when a home warranty wouldn't cover the water heater, what was the reason?
One of them was they said it was pre-existing. The other was we didn't have a home warranty.
That's it. Well, everyone else just said thank you. It was great information. Thank
you, everybody. Look for those new forms when they come out. I think you've got a pretty good overview of the ones you need to know about. And if you need anything, I'm only a call away. You know that. Just give me a call. I might be a little slower calling you back when I'm at Lord Huron. But other than that, I'll call you right back.
Thank you, Walt.
Take care. Thank you. Bye-bye.
Bye, everybody.
Thank you.